Judiciary and Hawaiian Affairs. It is Tuesday, March 30th at 2 p.m. in conference room 325. Members, we're going to be taking one item out of order in light of the translator needed. It's going to be SB 1034 SD1 HD1 relating to Sunshine Law Boards. First up to testify, we have DLNR. Oh, I'm sorry. First up, we have the DCCA with comments.
Good afternoon, Chair Nakashima and committee members. Doreen Eddy from DCCA. You have our submitted comments and I am here to answer any questions that you may have. Thank you.
Thank you. Next up, we have DLNR in support.
Good afternoon, Vice Chair, Chair, committee members. Kevin Moore with DLNR. The department stands on its written testimony and support. We're available for questions. Thank you.
Okay, thank you. Next up, OIP in support. Not present. Next up, Disability and Communications Access Board in support. Colin, are you there?
He is. He's waiting for the interpreter.
Okay. Should we come back to him?
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Colin Whited, and I'm going to testify on behalf of Kirby Shaw, the Director of Disability and Communication Access Board. We stand on our testimony with comments. Some revisions have been legitimate and ADA, there are legitimate ADA compliance concerns, using myself as an example. I equally access public meetings using an American Sign Language interpreter. And I'd like to use two examples that could arise and cause ADA issues. The first example is I may request a interpreter for a public meeting that is scheduled, the interpreter is scheduled from 2 to 4. And then due to technical issues, the meeting may end and then start again at 4. And my interpreter is only reserved until 4. So that means my access is denied. Also, a second scenario could be maybe the meeting is having problems with visual and they reconnect only using audio and there's no visual. So that means that I'm denied access to these public meetings. So we need to come up with other ways like support services or captioning, but it means that agencies may inadvertently violate the ADA law. Thank you very much for the opportunity to testify. I'm here if you have any further questions. Thank you.
Yeah, thank you. Next up, we have Department of Transportation in support.
Good afternoon, Chair, Vice Chair, members. Lena Rocky-Regan from the State Department of Transportation. We stand on a written testimony and support. Thank you.
Okay, thank you. Next up, we have Kelly King from the City Council in support.
Aloha, member. Can I speak now?
Yep, go ahead.
Okay, thank you. I haven't been on this end in the virtual testimony, but I want to thank you for the opportunity, Chair Nakashima and honorable committee members. It's great to be here, and I'm here because Maui County Council has been using interactive technology since the beginning of this pandemic, so we have a full year of experience. And we've actually noticed an increase in public participation and public engagement since we've started. We've gotten a lot of praise and appreciation, a lot of patience and forgiveness for some of the technical glitches we once in a while experience. But overall, folks have just been really glad to be able to have the ease of testifying from their home or their office or even their yard or the beach. We even had people call in from walking down the street and being able to participate and give their testimony. So I want to thank you for your consideration of Senate Bill 1034. I think it's one of the most important pieces of legislation going forward to allow us to continue the use of interactive conference technology to conduct remote meetings under the Sunshine Law, even if there's no emergency declared by government authorities. I also want to ensure you that we adhere to whatever ADA laws there are in our in-person meetings, and we do so as well in our virtual meetings. So the last point I want to make, and I do have written testimony in support, but the last point I wanted to make is that this way of doing business has actually increased our productivity. We've never taken a hiatus, although sometimes I wish we had. We've actually been working harder than ever. And we also have the broader civic engagement, but we also have the added benefits of more efficiency and reductions of both traffic and emissions. So it's been a really efficient way of doing business, increasing transparency and public participation. And I ask for your strong support of Senate Bill 1034, SD1, HD1. And thank you in advance for your forethought in bringing Hawaii into 21st century governance. Mahalo.
Thank you. Next up, we have Hawaii Civil Rights Commission in support.
Yes, thank you, Chair, Vice Chair, and members of the committee. We stand in support. I just had a few comments. We had some concerns that the accessibility requirements in the Senate draft one were removed in the House draft one. We thought that they were a good addition as far as they went, and the removal might cause problems with ADA compliance. The other question we had is the availability of, or the mandate that a public place be provided. And we would like clarification from the legislature or OIP about whether the computers at public libraries satisfy the public meeting location. And that's kind of important because otherwise departments and divisions need to set up a place that would have a computer. So I've been asking that question since the beginning of session, and I don't know the answer. But other than that, we support the bill and rest on our testimony.
Thank you. Next up, we have Civil Beat Law Center for the Public Interest in support.
Good afternoon, Chair, Vice Chair, members of the committee. Brian Black, Executive Director for the Civil Beat Law Center for the Public Interest. Supporting the bill, the only concern is the language that was added in the last committee with respect to removing the requirement to have an in-person location. In light of the digital divide issues, not having a physical location for people to go to is a significant problem. And it may not be, it could be that someone can't afford devices to connect. It could be that they just don't have the technological facility to work with all of the different types of programs. I've logged into these programs from the beginning using Zoom, WebEx, BlueJeans, you name it. I've attended meetings on it, Teams, and it's not easy to figure out all these different programs. So we shouldn't be putting barriers in front of people to be able to connect to these meetings. So I think there should always be at least one in-person official location that folks can go to if they're uncomfortable with the technology. Available for any questions. Thank you.
Thank you. Next up, we have Common Cause Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. You have our written testimony before you. We stand upon it and are available for any questions. Thank you.
Thank you. Next up, National Federation of the Blind of Hawaii in support. Okay, not present. Members, we have a number of individuals submitted testimony, all in support. 2 are present, hopefully. Today, first up, we have P.L. Fritz in support.
I hope you can hear me now.
Yep, we can hear you.
Thank you. My name is Peter Fritz. I'm an individual with a disability. I often request ADA accommodations for meetings. Specifically, I request live captioner. When I request an agency to provide me with an accommodation, that accommodation is for the scheduled length of the meeting. So if the meeting starts at 1 and ends at 4, they request and set up an accommodation for me for that period. I have proposed and suggested that this bill provide that a meeting end at the scheduled time for the meeting. The draft as unamended says that if there's technical difficulties that the meeting shall end. This bill allows for time to repair or correct the technical difficulty. And if the meeting is to end at the time scheduled, then the agency is protected because the meeting doesn't go beyond the accommodation they reserved to me. This doesn't involve the ADA. It's there primarily to protect the agency from inadvertently violating the ADA. And it doesn't require OIP to do anything to enforce the ADA as has that been a concern of theirs in past testimony. So I respectfully asked the committee to add language that might end the meeting if there's a technical difficulty at the scheduled time. I will stay around if there are any questions. By way of background, I've been past chair of the State Rehabilitation Commission as well as of DCAB and served several terms on DCAB. Thank you for the opportunity to testify.
Thank you very much. Next up, we have only a first name, Nikki.
Aloha, this is Nikki Capo. I'm sorry I didn't have my last name on there, but thank you for taking this time. I just wanted to advise that I'm in full support of this and to support both Colin and Peter's statements. I serve on the disability board as well. My son is deaf, and I've been to many hearings in person where there was either no accommodations provided or a lack of accommodations. So it really inhibits those that need to speak out and share their views on what's going on with the bill. They're not able to do it effectively. With the COVID and having us to do it virtually, it just adds another layer that you were all witness to at the beginning in a delay to set up the interpreter as well as the disability member that's on the call today. So I just ask that you consider making those amendments to the bill. I do support it, but it is very difficult for individuals with a disability that need accommodations to get it effectively heard, and also for that information to transpire so that we make these services available to them. I believe all these hearings are for us to make a change in our state. So I really highly recommend it be considered to make it open to all of us. And if it needs to be rescheduled for certain bills, that it's done so to ensure that we have those accommodations and adequate accommodations met. Thank you.
Thank you, members. That's all the testifiers we have on this measure. Any questions? Rep Board.
Mr. Fritz, please. Peter Fritz.
Yes, sir.
Mr. Fritz, do you have page and line number for your proposed amendment? You said you have something, but do you know specifically where it would benefit the committee to see specifically? You haven't got it yet.
I don't have the exact line number. If it would help the committee, I can go back to the bill and look up the exact section and line number.
That would be very helpful. Second question I have is to Ms. Ma from Common Cause. Sandy, are you there?
I'm here, report. Yes.
Sandy, you suggest, or is it something that is there, but I didn't see that when you are in a meeting, you've got to be visible. No incognito. Is that the position of Common Cause? That it
Yes.
should say, if you're in the meeting, you're not just for quorum, you're for forever to be visible. Is that correct?
That is Common Cause's position, that if you are a commissioner or a board member and you are at the meeting, Common Cause's position is that you appear on camera instead of just be on camera if you are there for quorum purposes. That's because if people are presenting, then it would be good for the public to know that the members are aware of and paying attention to the public.
And what is the practice, the experience rating of that? If I look at this Zoom call, it looks like about 1/3 of us are on camera and about 2/3 are off. So we would disqualify.
It would, as you know, the legislature is not subject to sunshine law.
Oh, that's right. We're all these exempted. Okay, thank
But
you.
if the legislature would like to be subject to sunshine law, we would support that also.
Some of our faces are not as attractive as yours and others on this
I
call.
think report is making a suggestion, or not
Oh,
making a suggestion.
We've gone beyond the chair's reminding us. Okay, thank
Yeah,
you.
thank you, report. Anyone else? We need one of those hooks. Anyone else? Any questions? Okay, if not, we will recess briefly for decision-making on this matter and the deferred matter from yesterday. Recess.
Yeah, thank you very much. For SB 1034, SD1, HD1 relating to the Sunshine Law Boards. Chair's recommendation is that we amend the bill to first on line 4, lines 8 to 13. The option to provide additional locations open to the public is optional. Clarify that, and also that on page 3, line 16 to 19, list at least one setup for audio and visual 3 working days before the meeting, so that if you do request an audio visual, that it be done at least 3 days prior to the meeting. Hawaii Employer Union Voting suggested that we require a recorded vote on business action items. Actually, they wanted a vote on everything. And what I'm going to suggest is that we require a recorded vote on business action items. So incidental motions to adjourn and such need not be a recorded vote. We will go with common causes request to that everyone should be visible and audible throughout the length of the meeting. And what I would like to also, and also on page 3, line 8, I would like to add, after technology, provided that the interactive conference technology used by the board allows audio-visual interaction among all members of the board participating in the meeting and all members of the public attending the meeting except as otherwise provided under this section. Also, technical amendments needed for clarity, consistency, and style. And in the committee report, I do want to note that if accommodations requested and meeting goes beyond scheduled time, the meeting should end as scheduled and a new time and date provided. And in question to the public libraries being a acceptable public access meeting public access requirements, the public libraries can be meeting public access requirements to the extent that the library rules provide, the local library rules provide. Okay, members, any questions or comments on that?
Sure.
Yes.
Thank you for those amendments. I thought you were going to get to the Peter Fritz amendment where if you're with a disability, you will be accommodated till the end. But what you said is the meeting must end when it's supposed to end. Is
Yes.
that basically what you're saying?
Yeah.
So there'll be no disadvantage to anybody who's part of
Yeah. So
whatever.
so if it cannot end on, for whatever reason it cannot end on time, it should end and another meeting scheduled.
Okay, that's good reverse engineering. Thank you very much.
Yes, Representative Tokioka.
Thank you, Chair. I just want to get some clarification. You said 3 days in part of your, in the beginning of your additions that you were going to add to the bill
Yes.
for notification, or I couldn't clearly.
So if you want they have to declare a public access site. And if you are actually going to show up there, in order for them to provide for the audio and visual, 3 working days prior to the meeting.
Okay.
So
is it going to be 3 days?
So
or
it's not an
7?
obligation of the agency to have the site and
Right.
have the equipment
accommodation,
there
yes.
until somebody says that they
And so
will
that's
be
fair.
there.
So is it going to say 3 days or 72 hours?
I'm going to say 3 working days.
Okay. Okay. Thank you.
Members, any other questions or comments? Okay, seeing none, Vice Chair as amended.
The Chair's recommendation is to pass SB 1034, SD1, HD1 with amendments. Chair and Vice Chair vote aye. Rep. Ichiyama? Aye. Rep. Kobayashi? It's excused. Rep. Lopresti? No, excused. Rep. Lowen? Aye. Rep. McKelvey?
Aye.
Rep. Nakamura?
Aye.
Rep. Takumi?
Aye.
Rep. Todd? It's excused. Rep. Tokioka?
Aye.
Rep. Ward?
Aye.
Okay, Chair, your recommendation is adopted.
Okay, thank you very much. Can we do that?
It's on here. Oh, sure. Okay, so we're going to turn now to HCR 131 HD2 or HD1 from the previous agenda, and buckle up because there's a lot of things here. So we're going to be amending the resolution or amending the title to read House Concurrent Resolution requesting the establishment of a working group to review and recommend improvements to the operations of the island burial councils within the State Historic Preservation Division. We are removing DLNR on the committee. We are adding references in the preamble to HRS section, chapter 10, certain sections of that. We are removing DLNR as a vetting agency for potential burial council members. We are adding the history and culture branch chief of SHPD or one of their representatives. Same with DoCare, adding DoCare's chief or one of their designated representatives. By request from OHA, we are adding their CEO to the working group, but we are removing all other OHA members, including the representative from the Board of Trustee and the 2 staff members. We are adding a member of the Dean of the William S. Richardson School of Law, or that Dean's representative, and we are taking out the 2 members designated by the House and Senate, 1 each, and substituting them with 2 people, 1 a lineal descendant and 2 a cultural practitioner, both selected by Huli Au'apa'a. We are inserting language to clarify that the working group needs to focus on recommending ways to implement their proposals, deleting the requirement for the working group to discuss how to fill current and future vacancies on the council, removing the need to examine SHPD staff duties and responsibilities. Actually, I think that was just moved and not removed entirely. Adding OHA as the convener for this working group, removing the chairperson of OHA as someone who would receive a copy of the concurrent resolution, and making technical non-substantive amendments for purpose of clarity, consistency, and style. Any questions?
So the SHPD duties and responsibilities is still in there, right?
Yeah, I believe this document that I was sent is not correct. I believe it is in a different place.
Okay, if we could, sure, that'd be great, Chair, 'cause I know a lot of the testimony, particularly from my island, was.
Yeah, in fact, I'm looking at it right now. Okay. So the working group is still going to examine ways to improve the implementation of the Island Burial Council's duties and responsibilities, and to better understand and determine their relationship to SHPD and its management.
Thank you, Vice Chair. Appreciate the clarification.
Rep. Tokioka.
Thank you, Vice Chair. So did you say you're going to make changes to the title, or you're changing the title?
I believe the title is slightly changed. It's not really that substantive. We're deleting, instead of a burial sites working group, it's just the working group now. Oh. And recommending improvements to the operations of the Island Burial Councils. Okay. Instead of, yeah.
The way you said it, it kind of got me worried.
Oh, yeah. No.
Thank you.
It was just kind of to clarify it. Yeah. My mistake. Any other questions or comments? Okay. If not, Chair, as amended.
Okay, HCR 131, HD1, with amendments, Chair and Vice Chair vote aye. Representative Ichiyama. Aye. Representative Kobayashi. Excuse. Representative Lopresti. Excuse. Representative Lowen.
Aye.
Representative McKelvey.
Aye.
Representative Nakamura.
Aye.
Representative Takumi.
Aye.
Representative Todd. Excuse. Representative Tokioka.
Aye.
Representative Ford.
Aye.
Okay, motion is adopted.
Yeah, thank you, members. Do we need to recess, or do you want to just go on?
Just go on.
Okay, so let us move this train down the road. Next up is SB 367 SD2 HD1 relating to water quality. First up, we have DLNR in support.
Thank you, Chair, committee members. Sam Lemo, DLNR. I stand on our support for this measure.
Okay, thank you. Next up, we have Hawaii Shore and Beach Preservation Association in support.
Thank you, Chair. We stand on our testimony. Just want to reiterate a couple of points. Our beaches are eroding. Seawalls lead to beach loss in an erosive system. Sea level rise, things are going to get worse. We need erosion mitigation alternatives, specifically nature-based solutions such as the SFDR. Small-scale beach restoration includes water quality BMPs. There's no need for redundancy. And the waiver has been very successful for the fish pond restoration program. This is all in line with the permit streamlining recommendations that were discussed last week during ASBPA's National Coastal Summit. So thank you.
Okay, thank you. Next up, we have the Waikiki Beach Special Improvement District Association in support.
Yeah, thank you, Chair, Vice Chair, and committee members. My name is Dolan Eversole on behalf of Rick Egged with the Waikiki Beach Special Improvement District Association. We stand on our written testimony and are available for questions as needed. We are in support.
Okay, thank you. Members, that's all the testifiers. Any questions? Okay, seeing none, we'll move on to SB 347, SD1, HD1 relating to litter control. First up, we have DLNR in support. Brian, are you there? Okay, guess not. Next up, we have Beach Environmental Awareness Campaign Hawaii in support.
Aloha, Chair Nakashima, Vice Chair Matayoshi, and committee members. My name is Suzanne Fraser. I'm testifying in very strong support of SB 347 on behalf of Beach Environmental Awareness Campaign Hawaii Beach. Thank you so much for hearing this bill today. Balloons are one of the most lethal types of marine debris, which is why this bill is important and necessary. It doesn't ban the balloon itself, but the release of the balloon, and the industry supports this bill. Balloons undergo a process called brittle fracture in the air, where they burst, causing a shredded appearance that marine animals and birds can mistake for their food, such as jellyfish and squids, due to their tentacle-like appearance. We'd like to recommend that this bill is amended to take effect upon approval, because it's a very straightforward bill and we don't feel that there is a need for further discussion on this bill. Hawaii is a state surrounded by water, and it's imperative that action is taken to prevent one of the most hazardous types of litter from getting into the ocean and becoming marine debris. We've included a petition with our testimony of more than 1,500 people who've signed a petition in support of state action on marine debris, including banning balloon releases. Thank you so much for this opportunity to provide testimony in very strong support of SB 347. Mahalo.
Okay, thank you. And I'm told that we need to take a brief recess for the translator, the sign language interpreter to log off. So we'll just take a brief recess for that. Recess. Still on SB 347 is the Hawaii Reef and Ocean Coalition in support.
Thank you, Chair, Vice Chair, members of the committee. Ted Boland on behalf of Hawaii Reef and Ocean Coalition in strong support of this bill. Release of balloons, as the previous speaker indicated, is very toxic for marine life. And the Hawaii Reef and Ocean Coalition is very concerned about the effect on various types of marine species from this plastic marine debris, which ends up often in the ocean from balloon release. We would ask for an amendment to make this effective upon approval rather than a 2050 defective date. As the previous speaker indicated, this is not a controversial bill and there's no reason for additional discussion. We'd like to see this move forward with that amendment. Thank you very much for the opportunity to testify, and I'm available for any questions from the committee.
Yeah, thank you. Members, we have a number of individuals testifying in support, submitting testimony in support, about 30 of them, maybe 20. Two here to testify today. First up, we have Susie Wallace in support. Okay, not present. Next, we have Dean Otsuki in support.
Aloha, Vice Chair Matayoshi and Chair Nakashima. I'm in very strong support of SB 347, which will prohibit the intentional release of balloons inflated with gas that is lighter in the air. Balloons are basically flying pollution. Wherever they land, it ends up as pollution. And since we're on an island, most of the balloons that do go up in the air, they end up in the ocean. And a lot of marine life mistake those balloons as their food, which causes harm for these animals. Done a lot of cleanups and found a lot of balloons on the beaches, especially during graduation time. The only amendment I would have, like the prior speakers have said, that for the bill to take effect upon approval, and also I'd like to say there are other alternatives for balloon leases or celebrations. That would be, giving lays, planting a tree garden, etc. Thank you for giving me the opportunity for providing testimony.
Okay, thank you. That's all the testifiers we have today. Members, any questions? Our board.
Okay. I'm not sure who to direct this to, but I'm trying to see what types of balloons that this is referring to, and then what may be the experience rating of those that are intentionally or those that are unintentional. Does anyone have any data or metrics on this particular measure? Sorry, I'm giving it open-ended, but I'm not sure who may be able to answer it, or maybe no one actually knows some of the numbers. Chair, hearing none.
Oh, can I speak or?
Oh, Ms. Fraser, is that you?
Yes.
Please proceed.
I'm not sure which numbers you're interested in, but there was a mass balloon release on Oahu last June, and it was over 2,000 balloons that were released at that one event. This bill is about intentional releases, not accidental releases. So an event such as that was planned ahead of time, that would be the kind of event where the release of the balloons would be banned under this bill. And we'd hope that the organizers would look at an alternative. You know, there's many good alternatives to commemorating or celebrating.
So we're talking primarily about celebratory balloons or events that are celebrations of something or an occasion. Is that correct?
Yes, not just celebrations. The one last year was actually commemoration of someone passing away.
Oh, I see, a memorial.
Mhm.
The second, if we know, how do we tell something is intentional or unintentional? How do we enforce this?
Well, you know, these intentional mass balloon releases are planned ahead of time. You know, they have to go buy the balloons and advertise and get all the people there. So that's an intentional balloon release. An unintentional balloon release would be, you know, a child is given a helium-filled balloon and they accidentally let go of it. These mass balloon releases, I mean, they're mass balloon releases, so it's more than just one balloon being released into the air at one time.
Thank you very much for those numbers. Thank you, Chair.
Thank you. Any other questions? Seeing none, we'll move on to SB 399 SD1 HD1 relating to the orders of the Campaign Spending Commission. First up, we have Campaign Spending Commission in support.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Gary Kam, and I'm here on behalf of the Campaign Spending Commission. The commission will stand on its written testimony in support. Thank you.
Okay, thank you. Next up, we have Common Cause Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We stand on our written testimony in support of SB 399 SD1 HD1. Thank you.
Okay, thank you. That's all the testifiers. Members, any questions? If seeing none, we'll move on to SB 403 HD1 relating to reports filed with the Campaign Spending Commission. Up first, we have the Campaign Spending Commission in support.
Good afternoon, Chair, Vice Chair, members of the committee. Gary Kam on behalf of the commission. This one, we would ask that the committee restore the original form of the bill that was passed out of the Senate. The attempt to figure out the intent to remain politically active after the primary election would be pretty hard for the commission to ascertain. Thank you.
Okay, thank you. Next up, we have Common Cause Hawaii in support.
Good afternoon again, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We support SB 403 HD1, but we do share the Campaign Spending Commission's concerns about how to ascertain candidates' intent. I'm available to answer any questions. Thank you.
Okay, thank you. Members, that's all the testifiers we have. Any questions? I believe Chair Nakashima had a question.
Campaign spending. You know, the one concern raised by testifiers was that, if we pass this bill, that we will never find out who contributed to that candidate. Is that accurate?
Well, that's, there's an ongoing obligation to file reports. This one just deals with the preliminary reports. For the preliminary general reports, if you are either if you either lose in the primary or you or win in the primary, then you don't have to file those preliminary reports. But then you would still have to file the final election period report and any other supplemental reports that happen after that until your registration is terminated.
Okay, thank you very much.
Okay, thank you, members. Any other questions? If not, we'll move on to SB 200 HD1 relating to elections. First up, we have Campaign Spending Commission in support.
Good afternoon again, Chair, Vice Chair, members of the committee. Gary Kem on behalf of the commission. The commission will stand on its written testimony in support. Thank you.
Okay, thank you. Next up, Common Cause Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. Testified in opposition to SB 200 HD1. There was a question by Chair Nakashima, and we are concerned with knowing the donors to candidates prior to elections. We think that is highly important for the public to understand who has been donating to people running for office. And so that's why we feel like disclosures are highly important, especially prior to election day. Thank you, Chair and members of the committee for being interested in campaign finance issues, and of course for the Campaign Spending Commission for transparency and accountability in enforcing our campaign finance laws. I'm available to answer any questions. Thank you.
Thank you, members. Any questions? Okay.
Yeah, I guess I have the same question again for the Campaign Spending Commission. So, given Common Cause's concern, would it mean that we would never know who contributed to the candidate because they do not need to file the preliminary general report?
Well, again, you would still need to file the final election period report and any supplements after that, as well as any prior reports that you would have needed to file for the primary election. Keep in mind that what this bill does is actually consistent with an existing statute, 11-334, regarding the filing of preliminary, final, and supplemental reports. So those are required if you're on the ballot. And if you're not on the ballot for an election, then you just file the supplemental reports. So this is nothing new. It's just applying it to the late contribution reports.
Okay, thank you very much.
Yeah, thank you, members. Any other questions? If not, we'll move on to SB 826 SD1 relating to sex offenders. First up, we have the Attorney General's Office in opposition.
Good afternoon. My name is Michelle Pu'u. I'm a Deputy Attorney General for the department. While we appreciate the intent of this bill, we respectfully oppose it in light of constitutional and practical considerations. I am available for questions.
Thank you. Next up, Public Defender's Office in opposition.
Aloha, Chair Nakashima and members of the committee. The Office of the Deputy Public Defender, Darcia Forrester. The Office of the Public Defender does not oppose geographical restrictions for a person on the sex offender registry. However, we do strongly oppose a mandatory geographical restriction, especially one that mandates a 2,000 feet restriction radius without any provision that allows input from a victim or the family of a victim. This measure assumes that all victims want a geographical restriction imposed. A victim who does not want a geographical restriction cannot and should not, a victim who does want a geographical restriction cannot and should not be the spokesperson for a different victim who does not want the restriction imposed because they may want a family member to return home. Each situation is unique and the measure should be amended to allow for family reunification or exceptions with the permission of the victim or the victim's family if that is what they want. Mahalo, and I'm available for any questions.
Thank you. Next up, Hawaii Paroling Authority in opposition. Not present. PSD in opposition.
Hi, good afternoon, Chair, Vice Chair, committee members, Max Otani, Department of Public Safety. We'll stand on our written testimony in opposition of this bill. I also have Tommy Johnson here who will be able to answer any questions you have of us. Thank you.
Okay, thank you. Members, we have a number of individuals testifying, all in support. Only one present is Shireen Bales. Shireen, are you there? Shireen, we cannot hear you. Looks like your connection is not too good too. Yep.
Can you hear me now?
We can hear you.
You can hear me?
Yep, go ahead.
Can you see me? I'm trying to move to a different location because I'm actually really surprised. Can you hear me?
Yep, we can hear you now. You can go ahead with your testimony.
Thank you. I'm pretty surprised that all three of the government offices are opposing this because what we really need is accountability for the crimes that these people are actually committing, and to allow them to come around the people that they actually did the crime upon. That's kind of unfair to the victim because they did actually commit a crime. And I know they paid for their crime, but in actuality, if you guys really look at the statistics, only me came 1% of anyone who's been affected by this. That's kind of I'm a Kanak Maoli, and I'm speaking up for everybody in this world right now. No one else can come forward because they're afraid that their abuser came, or they're going to come. The abuser is going to come towards them. I don't understand why 2,000 feet is really not that much feet. That really surprised me, you guys. I'm really kind of upset with you folks. You guys are supposed to be protecting the community. No one wants to come forward because of the fear that they have for their abusers. And these abusers, they do it even when they went to jail, they're going to come out and do it again. That is the statistic. And that is something that you guys need to be accountable for. I'm really surprised. How dare you guys do that to people like us? I may be the only one that came forward because I want my family to be protected. I want the rest of the community to be protected. Where are the community? You guys are the ones that represent us, but you guys are the ones that have to make the decisions for people like us that are afraid to come forward. And that's what I have to say. I'm in strong support of this bill. Those people who commit the crimes, they deserve to be punished. And that's not just because I'm a grumpy woman.
Thank you for your testimony.
Thank you.
Any questions? Seeing none, we'll move on to SB 1050, SB1, relating to criminal history record checks. First up, we have the Attorney General's Office in support.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, Christopher Young, Administrator of the Hawaii Criminal Justice Center for the Department of the Attorney General. This bill is important as it will allow the department to comply with federal regulations in doing criminal history background checks for individuals that receive access to federal tax records. We have proposed testimony. We'll stand by that testimony, and I'm here to answer any questions you may have. Thank you.
Next up, Department of Taxation and Support.
Good afternoon, Marky on behalf of Isaac Toy and the Department of Taxation. The department will stand in strong support of this measure. I'll be happy to answer any questions you may have. Thank you.
Thank you. Members, any questions? Okay, seeing none, we're moving on to SB 343, SB1, relating to sexual assault of an animal. First up, we have Honolulu Prosecutor's Office in support. Mark, are you there? Nope, not present. Okay, next up, Hawaii Humane Society in support.
Aloha Chair, Vice Chair, Committee members, Stephanie Kendrick for the Hawaiian Humane Society. We are in strong support of SB 343. You have our written testimony, which highlights the mountain of evidence and research that compels that support. I wanted to spend my brief time with you this afternoon, though, just thanking you for your courage. Lawmakers in all 46 states that have passed similar laws have had to muster the will to do so despite criticism about misplaced priorities. And some of that criticism is just a reflection of ignorance. People don't want to believe that this is happening in their community. The problem is we know it is happening in our community and we need to be able to stop it. The snarky comments in response to the Star Advertiser today may just reflect a juvenile sense of humor, but there's nothing funny about the fact that people from across our state are in chat rooms boasting about having sex with animals, seeking animals for sex, offering animals for sex. And they celebrate the fact that our laws don't take these despicable acts seriously. There have been at least 5 arrests related to animal sexual abuse in 4 different states in just the first few weeks of this year. In every single case, the accused either has a history of child abuse or faces additional charges related to child abuse or child pornography. Every single case. There's nothing funny about it. Protecting the most vulnerable in our community should be the government's top priority, and I know you all understand that. So I want to thank you for having the courage to stand up and support this bill and give law enforcement the tools it needs to protect our community from these sorts of predators. I'm happy to answer any questions. Thank you.
Thank you very much. Next up, we have Pono Advocacy in support.
Aloha, aloha. Chair Nakashima, Vice Chair Matayoshi, Inga Gibson, Pono Advocacy, also in strong support. Unfortunately, I can add attest to Stephanie's testimony. I have worked on a number of animal sexual abuse cases across the country in my 20 years of animal protection work. And unfortunately, these are the kinds of incidents that you don't normally hear about until it is front page of the news or other. These are crimes that occur more frequently than many know. And sadly, it's not until these cases come to the forefront that oftentimes legislatures finally act. I was involved with the Washington State Legislature enacting a similar law, which was prompted by a case that involved the death of a man. Again, a very serious matter. So we applaud the committee and the legislature for taking this matter seriously. This really is, like many other animal cruelty and animal protection measures, about making safer communities for all. There are parallels between those who abuse animals and those who abuse children. And so I'm happy to answer any questions and urge your strong support of this measure that unfortunately needs to be clarified in statute. Mahalo.
Yeah, thank you. Members, we have about 30 or 40 individuals writing in support, 2 present, hopefully. First up, Johnny Kelly. Okay, not present. Next up, Jenny Edwards.
Hi, thank you, members of the committee, chairperson and vice chair. I second everything that both Inga and Stephanie said. I am a researcher and investigative consultant on these cases. This is all I do. It's what I specialize in. And the key thing is bestiality is a form of sexual assault. It's very different from a form of, it is a form of animal cruelty, but it's very different from neglect and that kind of physical abuse. So it's really, it has tentacles in unbelievable places. It happens far more often than people realize. It's far more insidious than people realize. And I am in strong support of your passing this bill. This will make Hawaii not in that group of 4 states remaining. We'll now have Wyoming is also looking at a similar measure. And that means that pretty quickly, we're going to have the entire country taking notice of the seriousness of this crime. So thank you very much for your time today. I stand behind the submitted testimony that I've previously sent, and I am here to answer any questions that you may have. Thank you.
Thank you. Members, any questions? Okay, seeing none, we'll move on to SB 834 HD1 or SD1 HD1 relating to childlike sex dolls. First up, we have Honolulu Prosecutor's Office in support. Is he here though? No. Okay. And that is actually the only testifier we have scheduled today. So I guess we've got nobody, but a lot of testimony in support, written testimony in support. Okay, next on the agenda is SB 764 SD1 HD1 relating to human trafficking. First up, we have Department of Transportation in support.
Good afternoon, Chair, Vice Chair, and members. Lena Rocky Regan from the State Department of Transportation. We stand on a written testimony in strong support of this measure and are available for questions. Thank you.
Okay, thank you. Members, that's all the testifiers. Any questions? Yep, seeing none, we'll move on to SB 309 SD1 HD1 relating to privacy. First up, we have Prosecutor's Office in support.
Good afternoon, Chair, Vice Chair, members of the committee. Chris Van Marter, Deputy Prosecutor, City and County of Honolulu. As the committee knows, SB 309 was the product of the 21st Century Privacy Law Task Force that met in 2009. This bill was passed by the task force unanimously. I was a member of the task force. The ACLU was a member of the task force, and SB 309 had unanimity between the prosecutors and the ACLU. The bill was introduced last year and it was passed unanimously by the House. It went to the Senate, and unfortunately, toward the end of the session, COVID hit and the bill was not heard by the Senate. This year, it was reintroduced as SB 309. The Senate Judiciary Committee took this up as one of their first bills, and this bill passed the Senate side unanimously, went to the House, where a couple of weeks ago, the Commerce and Consumer Protection Committee added an amendment from the Motion Picture Association of America, which is a very unfortunate amendment. That amendment, in effect, adds language that renders what the task force did as a hopelessly vague and ambiguous bill that's going to be almost impossible for prosecutors like me to prosecute. I have prosecuted this offense more than practically anyone in Hawaii. In fact, the 2014 amendment to the bill I wrote, the bill before that I wrote. I'm very familiar with this statute. What we're asking the committee to do is to restore the original language of the bill that was passed out by the Senate. Again, that's the same language that the House passed last year. Lastly, I would just point out regarding the Motion Picture Association of America's concerns about First Amendment, those concerns have been addressed. They were addressed in subsection B, which the legislature amended in 2014. The intent provision of subsection B is what makes the bill constitutional and renders the First Amendment concerns not valid concerns. That same intent clause from subsection B was added to subsection C. With that, this is a constitutional bill, so we would again respectfully ask the committee to restore the original language from SB 309 passed out by the Senate. I'll be available if the committee has any questions. Thank you.
Yep, thank you. Next up, we have IATSE Local 665 in support. Okay, not present. Members, any questions? Report.
Mr. Vice Chair.
Oh, I'm sorry. Is this the IATSE?
No, this is Melissa Patak with the Motion Picture Association. We're not on the list because, right, I hadn't planned on testifying because we had agreed amendments in the previous committee, and it was only upon review of the testimony earlier today that I saw the prosecutors were in opposition to our amendments. They had not reached out to us, and I apologize for having to kind of barge into the committee hearing. I would like to answer the points.
Nakashima, you can have 2 minutes to testify. Go ahead.
Great, thank you so much. Thank you so much. So we had interest in this bill last year, and I think in part it was not only attributable to COVID that the bill did not advance, but we had been negotiating with our colleagues in the Screen Actors Guild, SAG-AFTRA, union about this issue. This is a very important issue to us. We have a law in California that we negotiated. We have a law in New York that we negotiated, and we took much of the language that we've asked to be amended in the previous committee from prior legislation in other states. I would point out that in California, while we don't use the exact word realistic, the definition of depicted individual, that is the person who is the subject or the victim of the deep fake, means an individual who appears to be giving a performance they did not actually perform. That's what we mean by realistic, that it looks to the reasonable person as if it's realistic. It doesn't mean realistic that the person actually did it. Of course, then that would defeat the purpose of the bill, but realistic that a reasonable person would see this as something that actually happened, even though it didn't happen. So with all due respect to the prosecutors, we have had some experience on this issue in other states, and we would request that the amendments be continued in this bill at this time. And I'm happy to answer any questions. I have other conversations offline, and thank you for your consideration.
Thank you, members. Any questions? All right, seeing none. All right, Molly first. Rep. McKelvey.
No. I'm saying we had a question.
Oh. Okay. Report.
Okay. I have a chair to the motion picture person.
Yes, I'm right here.
The question is, what's the difference between deep fake and fake? If that's
right, that's a very good question. The deep fake is the term that has deep fake is the term that has been coined over the last number of years to reflect a technology, an advance in technology that can manipulate an image that makes it look very real to the viewer. I don't know if you saw a couple of years ago, the actor, I believe his name is, I want to say Jordan Peele. He took an image of President Obama and he voiced things that President Obama never would say, but he had the inflection, he had the picture, the video, and he had the voice and the inflections that would have made all of us believe that that was actually President Obama. And that technology has come to be called deep fake. So I don't have any better explanation than that.
But the way that some of the wording in the bill was like it involved like sexual acts and putting heads on different bodies, etc. But then the question is, Saturday Night Live and what sometimes Pritchard and other people put heads on different animals to make different points about different issues. Where does the humor kind of overlap, if you will?
So those are the additional amendments that have been added to the bill, which is if it's in connection with commentary, criticism, or disclosure, or other kinds of speech. We are in the area of free speech. It is deeply offensive to us at the Motion Picture Association that someone's image would be paired up with some sexual performance that they never would have done. We also are offended by that. But as you point out, Representative, there could be commentary, there could be parody, satire, things that are protected by the First Amendment. And that's why it's important that that language be incorporated into this bill. exactly what you're right for the references that you're making to things like Saturday Night Live.
Very good point, because many of us in this room belong to that particular class of individuals that are often satirized and well, we just have a different way of looking at ourselves vis-a-vis the way some other people would have us look at. Thank you very much for that, Chair. Thank you.
Okay, thank you. Members, any other questions? If not, we'll move on to SB 714, SD1, HD2 relating to publicity rights. First up, we have all individuals, all in support. First up, William Meyer in support.
Good afternoon, Chair, Vice Chair. Bill Meyer here. I stand on my written testimony, but I got two matters I'd like to raise. One is the defective date of the statute, which is contained in Section 5. Those defective, I realize it's a convention that you folks use, but they can have unintended consequences. In the underlying case where Federal Judge Kaye found that the legislative intent that the bill apply retrospectively was ambiguous, in part because you folks use this convention of putting the effective date way out in the future to allow for further discussion. So I just share that commentary, and I assume that you will take care of the defective date, because if you leave that in there, it would undo the purpose of the statute. The second point I'd like to bring to your attention is I'd like you to consider including a specific statute of limitations provision in the statute. The current law does not contain a specific statute of limitations. So a court interpreting the law would have to either determine whether the 2-year statute or the 6-year statute applies. Most of the states that have adopted a postmortem right of publicity have a shorter limitations period than 6 years. So I would recommend that you folks include a specific 3-year statute of limitations for two reasons. One, it would bring us into conformance with other states that have shorter terms. But number two, all of the remedy provisions of the existing statute are borrowed from and are word for word borrowed from the U.S. Copyright Act. By including a 3-year statute of limitations, it would bring the Hawaii postmortem right of publicity statute into compliance with the Copyright Act. And why is that important? Because we have a significant body of common law, case law that's developed over the years interpreting the Copyright Act. And in this, the underlying case where Judge Kaye found that the legislative intent was not clear with respect to retrospectivity, the judge did rely on decisions of various courts under the Copyright Act because it's analogous, in some respects at least, to the right of publicity statute. So sure the defective date and consider the statute of limitations. Thank you very much.
Thank you. Next up, we have Julia Brodman.
Hi, everyone, Chair, Vice Chair, members. Can you all hear me? I'm on. All right. So thank you for the opportunity to testify. I stand on support in support of my written testimony as well. I'd also just like to piggyback a little bit off of something Mr. Meyer was saying about the defective date. For most statutes, if we put the defective date in and then switch it back to be effective on its approval. I think in this case, because we're dealing with retroactivity, it would be appropriate to have the date be, effective as of July 15th, 2009, which was, I believe, what was in the earlier draft. So I'm here for any questions as well. Thank you for the opportunity.
Okay, thank you. Next up, Lonnie Smith. Okay, not present. Last, we have Eric Kiape in support.
Mahalo, Vice Chair and committee members. Thank you very much for the opportunity to testify. I submitted a written testimony, but I'd like to add comments and like to also, in addition to what Bill Meyer had indicated, the purpose of this law is to clarify dates. And initially, in my experience, 2009, when I was the one that initiated with another, popular entertainer, and only because of my mother's musical recordings that she had done way back in 1946, where someone wanted to use her image and her voice and take those recordings and reproduce them. And she had been negotiating with this person for quite some time. And in the last 10 years of her life, I've been basically her manager. And so there's disagreements on that. One of the last statements that was given to her was, we will not do it. We may not do it now, but we will have an opportunity to do it later. 4 months after her passing in February of 2008, the release of that recording was done, and I had contacted the individual and I was told that I was not able to because there is no law in the state of Hawaii. So we had initiated the law. The law was passed in 2009, and another situation came up where it was not holding water, and the dates were needed to be clarified that it is for those who have passed on before the law was implemented, and that's the case of my mother, Auntie Genoa Keawe. Thank you very much for allowing me to testify, and thank you very much. If there's any questions, I'd be able to answer.
Members, any questions? Rep Ward.
Mr. Keawe.
Yes.
Please know that your mother was a legend and a treasure, and I would just encourage you to keep this up, even though I think this bill is probably going to pass. If it doesn't, don't lose heart. Continue doing what you're doing. Thank you.
Thank you, Representative Ward.
Thank you. Any other questions? Now we'll move on to SB 191 SD2 HD1 relating to condominiums. First up, we have CAI in support.
Chair, Vice Chair, and committee members, Phil Nerney for CAI. CAI is in support of this measure. We're available for questions.
Okay, thank you. We have a number of individuals, both in opposition, support, with comments. 3 are present today. First up, Jeff Sandino with comments.
Yes, good afternoon, Chair, Vice Chair, members of the committee. My name is Jeff Sandino, and I am offering comments. I am against non-judicial foreclosures as a whole, because I have seen how they have been abused in my own association, as well as how my clients have been abused by them as well. But I would like to at least offer some comments for changes to the bill. And what I would like to emphasize about these, hopefully, is that everybody agrees with these changes. So I did submit written testimony, but I want to highlight at least one that is the most important to me, which is the opt-out clause. The supporters of this bill say that, they are in favor of having an opt-out clause, which basically means that the condo owner can opt out of being subjected to a non-judicial foreclosure. Their support has been in every single testimony for this bill and its companion bill. And while condo owners certainly would, or people opposed to non-judicial foreclosures are opposed to them as a whole, they would certainly be in agreement to have as many protections as possible. So the specific phrase is this one here: an owner may preserve a potential defense. And I just ask that that be changed to an owner may opt out. Everybody is in agreement for that. And so, I don't see that it should be controversial to include that. And then I did include several other comments and suggestions in my written testimony. And I just respectfully ask that the committee review those suggestions as well. Thank you for the opportunity to testify.
Thank you. Next up, we have Dale Arthur Head in opposition. You're not present. And last, we have Ann Anderson.
Yes.
I have no idea if you're in support or opposition.
Yes, thank you. Good afternoon, Chair, Vice Chair, and members of the committee. I submitted written testimony on the bill. What I'd like to do now is to summarize some of the key points. First, it appears from reading the bill that, and its earlier drafts, that there's some confusion regarding the Hawaii Supreme Court's decision in Malawi. The first 3 drafts of the bill inaccurately stated that the Hawaii Supreme Court and Malawi relied upon a holding in another case that Act 282 is unconstitutional. It appears that that may have been the premise for the bill. The erroneous language was removed from House Draft 1, but Section 1 still reflects confusion regarding the Malabi decision. The decision in Malabi was related to non-judicial foreclosures under Part 1, not Part 6 of Chapter 667. Part 1 was significantly different than Part 6, and the decision in Malabi regarding Part 1 doesn't relate to Part 6. Senate Bill 191 is focused on non-judicials under Part 6 of Chapter 667 as amended by Act 282. In this regard, the bill is premature because the Hawaii Supreme Court has not yet addressed Act 282 as it applies to Part 6 non-judicial foreclosures. It is altogether possible that the Hawaii Supreme Court, when faced with a Part 6 non-judicial foreclosure case, will rule in favor of the associations. The better approach is to take a wait and see approach. Rather than predicting the worst and making changes that may be harmful and later prove to be completely unnecessary. Additionally, as I pointed out in my testimony, the bill is confusing because it contains contradictions. Section 1 states, in part, that a specific grant of power of sale and a condominium association's governing documents is not required for a condominium to have power of sale to foreclose non-judicially. And the purpose of the bill is to reiterate and declare this fact. But instead of doing that, the bill does the exact opposite by now requiring condominiums to have a power of sale provision in their project documents. This
Ms. Anderson,
contradiction will likely
conclude testimony. It's been 2
Pardon?
minutes. It's been 2 minutes. If you
Okay.
could conclude your testimony.
Okay, thank you very much. Just this contradiction will create problems when the court interprets the bill. I have stated other reasons that I find the bill to be problematic. I ask the committee to defer any action on this bill. Thank you so much for the opportunity to testify.
Thank you. Members, any questions?
I have questions.
Scooby.
Yeah, I have questions for Ms. Anderson.
Yes.
Is she there?
I am, yes.
Ms. Anderson, of course, you were well aware when Act 282 passed. That's when I was chairing the Consumer Protection Committee. So can you refresh my memory? Because it's been a while since we passed out Act 282, but would you agree that the whole intent, the legislative intent that either by statute or by the documents of a condo association, that the intent was to allow power of sale foreclosures as far back as 1998 when Part 2 of Chapter 667 passed? And then would you further agree in 2000, fast forward to 2012, when Part 1 was repealed, and then Part 6, the new Part 6 you alluded to, was adopted, that it also allowed for non-judicial foreclosures, either by statute or by the documents of the association?
That's exactly right. And Act 282 has a detailed legislative history in the preamble clause that goes through the past legislation. The Hawaii legislature has for years allowed condominiums to foreclose non-judicially, regardless of whether they have a power of sale provision in their project documents. Act 282 was adopted to clarify that intent after the Intermediate Court of Appeals came out with its decision in Sakal, finding that there was no such legislative intent. And so all along, it has been very clear that the legislature has intended condos to have this power. And this bill here, Senate Bill 191, is a complete reverse. It is almost as if the legislature is throwing in the towel and saying, well, okay, well, we will just give up and we'll go to this new way, when in fact, it has been a certain way all along where you don't need the power of sale provision in your project documents. And I would also point out, in this regard, the Hawaii Supreme Court has not ruled on Part 6. And Chief Justice Rectenwald and Justice Nakayama clearly stated in their dissent that they believe that associations have the power to non-judicially foreclose under Part 6, regardless of even Act 282. And so there's a good chance that the Supreme Court will uphold Part 6 non-judicial foreclosures, consistent with the intent of the legislature going back, 20 years when faced with this decision. So this bill is It's just somewhat astounding to me that the legislature would consider doing a complete reverse, undoing all that it has done all of these years, and then establishing a new procedure, which I think is also faulty, and I've pointed that out in my testimony.
So in other words, Ms. Anderson, the Community Association Institute in their testimony said that the courts therefore will not honor longstanding legislative intent without additional legislation. I guess they mean this bill, but what you're saying is, since the Supreme Court has not even ruled on Part 6 of the chapter, we're kind of putting the cart before the horse?
That's what I believe. So the Malabi decision was on Part 1. Then there was the so-called decision by the Supreme Court that also addressed non-judicial foreclosures, but the Supreme Court went to great lengths to say that that was under Part 2 and not Part 6, and
Right.
they expressly said that they were not going to rule on Part 6. They're not going to rule on the constitutional issue of Act 282 as it applies to Part 6. So
Okay.
they have not ruled on it. I'm sorry.
And then last point, in your testimony, you said that Section 2 will prevent
Yes.
associations from allowing their owners to vote on a declaration or bylaw amendment. That's very troubling because I think we all know one of the prevailing doctrines of condominium associations is that the owners really get to determine their destiny. So can you elaborate why Section 2 prevents associations from allowing their owners to vote?
Yes. Yeah, so Section 2 says that the board can adopt amendments of the Declaration of Bylaws, which is highly unusual. Even to conform to 514B, it takes a majority vote. Only in restatement can the board amend the documents, but that's to conform to the law. Normally, it takes owner approval. But the reason I say in my testimony that this will prevent owners from actually doing that is because it says that this is the exclusive procedure that condos may follow. They can't follow any other procedure. So even if a condo wanted to vote to put in a different provision for power of sale, even if they wanted to do a more elaborate provision that provided better consumer protection clauses, even if they wanted to do better wording, or even if the court strikes down this bill, condos would be not able to do an amendment to correct that or to adopt their own amendment because the bill says this is the exclusive procedure to be followed.
Okay. Thank you. Thank you very much, Chair.
Thank you. Members, any other questions?
Chair, may I follow that up with Ms. Anderson?
1 second. Chair, did you have something to add on the report?
Ms. Anderson, if we take your wait and see approach, do you have any estimation on how long that wait and see may be a wait and see?
I don't know. It's going to wait. It's going to have to be until a case gets back to the Supreme Court. There are cases pending. I'm not sure of the status of them. Many cases will end up being settled, as is with all litigation. But so I don't have a prediction on that.
In today's economy, is there an urgency to make this bill in or out in terms of its passage?
I don't think there. If the question is directed to me, I don't think there is an urgency. I think the bill will do more harm than good, frankly. I think it's a bill that should not be passed. And if the legislature wants to do something of this nature, it should defer it to a future year where attorneys in the legal community association industry could get together and at least work on the language. I'm very bothered by this bill.
Thank you, Ms. Anderson. Thank you, Chair.
Thank you. Members, any other questions?
Thank you.
Now we'll move on to SB 651, SD1, HD1, renaming the Kahului Airport Access Road. We do have a testifier today, Department of Transportation, in support.
Good afternoon again. The department stands on its written testimony in support of this measure. Thank you.
Okay, thank you. Members, any questions? Okay, seeing none, let's move on to SB 1270 relating to the Workforce Development Council. We have one testifier today, the Workforce Development Council, in support.
Good afternoon, representatives. I'm Allison Tasaka, Executive Director of the Workforce Development Council, testifying in strong support of this measure. I stand on my written testimony in this housekeeping bill to comply with federal regulations. Thank you.
Thank you. Members, any questions? Yep, seeing none, we'll move on to SB 1225, SD1, HD1, relating to the University of Hawaii Board of Regents Independent Audit Committee. We have one testifier today from the Office of the Board of Regents in support.
Good afternoon, Chair, Vice Chair, members of the committee. Kendra Uishi, Executive Administrator and Secretary of the Board of Regents. We submitted testimony in support of this bill, so we stand on that written testimony and just note that the committee passed out its companion measure HB 1071, which is substantially similar to this bill. Thank you.
Thank you. Members, any questions? Okay, seeing none, we'll move on to the last item left in our agenda, SB 540 SD1 HD1 relating to emergency rules. First up, we have the Attorney General's office in support.
Good afternoon, Chair. I'm sorry. Lance Goto with the Department of the Attorney General. We've submitted testimony in support of this measure and we will stand on that testimony. Thank you.
Thank you. Next up, Public Defender's office in support.
Yeah, good afternoon, Vice Chair, Chair, and members of the committee. I'm James Taubet with the Public Defender's Office, and we strongly support this bill. I just want to say civil infractions, such as for jaywalking and for seatbelt violations, they're effective and efficient. First of all, they're effective because I don't know too many people who have multiple violations of seatbelts. They usually after one or two times they comply, and they're efficient because these citations are efficient because they're easy to pay, easy to resolve. All you have to do is put your money in an envelope or pay online, and we're done with the case. Also, if you want to contest it, you write a written statement, and it can be done. If you disagree with the judge's ruling on it, you can have a quick trial at the end. So we are fully support, and we are available for questions. Thank you.
Thank you. And this is one of those rare times. Prosecutor's office from Honolulu in support.
And Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. I apologize. I had technical difficulties earlier, but we stand on our written testimony in support.
Okay, thank you. Members, any questions? Okay, seeing none, we will recess for decision making. Recess.
It pickles you. Okay. Good afternoon, folks. So Tuesday, March 30th, in conference room 325, we're here for decision making on our 2 o'clock agenda. First, we have SB 367, SD2, HD1 relating to water quality. Chair's recommendation is technical amendments needed for clarity, consistency, and style. Members, any questions? Seeing none, Vice Chair as amended.
The Chair's recommendation is to pass SB 367, SD2, HD1 with amendments. Chair and Vice Chair vote aye. Rep. Ichiyama? Aye. Rep. Kobayashi?
Aye.
Rep. Lopresti?
Aye.
Rep. Lowen?
Aye.
Rep. McKelvey?
Aye.
Rep. Nakamura?
Aye.
Rep. Takumi?
Aye.
Rep. Todd? Excuse. Rep. Tokioka?
Aye.
Rep. Ward?
Aye.
Okay, Chair, your recommendation is adopted.
Okay, thank you very much. SB 347, SD1, HD1 related to litter control. Chair's recommendation is that we pass it out as is. Members, as is. Any questions, comments? Seeing none, Vice Chair as is.
Chair's recommendation is to pass SB 347, SD1, HD1 as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. SB 399, SD1, HD1. Chair's recommendation on this is also as is. Members, any questions or comments? Seeing none, Vice Chair as is.
Chair's recommendation is to pass SB 399, SD1, HD1 as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. SB 403, HD1 related to reports filed with the Campaign Spending Commission. Other request from the previous chair, we will blank out the dollar amounts on this bill. Members, any questions or comments? Seeing none, as amended, Vice Chair.
Chair's recommendation is to pass SB 403, HD1 with amendments, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 200, HD1 related to elections. Again, we will blank out the dollar amount on this bill. And HMSO has recommended that we insert a proviso on line 12 that reads, provided that the slate contribution report does not need to be filed by a candidate or treasurer of a candidate committee if the candidate is not on the election ballot. Members, any questions or comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass SB 200, HD1 with amendments, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. SB 826 SD1 members, Chair recommends we defer this bill. SB 1050 SD1 related to criminal history record checks. I recommend that we input the AG's amendments and then pass it out as amended. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 1050 SD1 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 343 SD1 related to sexual assault of an animal. Chair's recommendation is that we use the prosecutor's language, page 7, line 21, unless otherwise provided by law. Also, I'd like to note in the committee report that the high potential, the high penalty in this case is a potential to act as a deterrent to sexual animals it has also been shown to be a precursor to child abuse. So on the first instance, on the first offense, it will be a misdemeanor and a felony C on the second offense. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 343 SD1 with amendments noted the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 834 SD1 HD1 relating to child-like sex dolls. Chair would like to note that amend page 3, line 20 to 21, adding features of or features that resemble those of a person below the age of puberty. Members, any questions or comments? Seeing none, Vice Chair as amended.
Okay. Chair's recommendation is to pass SB 834 SD1 HD1 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 764 SD1 HD1 relating to human trafficking. Chair's recommendation is pass it out as is. Members, any questions or comments? Seeing none, Vice Chair as is.
Chair's recommendation is to pass SB 764 SD1 HD1 as is noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 309 SD1 HD1 relating to privacy. Members, on page 4, I'd like to delete lines 8 and 9. Also on page 4, delete lines 11 and 12. Also technical amendments for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 309 SD1 HD1 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. SB 714 SD1 HD1 HD2 related to publicity rights.
HD1. At least I have HD1 over here. I don't know.
HD1 SD1 HD1. I'm sorry.
714. Oh, it is HD2.
We do propose amendments extending the right to be deemed existing before the enactment of this chapter, including at or after the time of death of any deceased individual or deceased personality. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass SB 714 SD1 HD2 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
SB 191 SD2 HD1. Following the colloquy by the former CPC chair, we will defer this measure.
Congratulations.
SB 651 SD1 HD1 related to the renaming of Kahului Airport Access Road. Chair's recommendations pass it out as is. Members, any questions or comments? Seeing none, Vice Chair as is.
Chair's recommendation is to pass SB 651 SD1 HD1 with or as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, SB 1270 related to Workforce Development Council. Chair's recommendation passes out as is. Members, any questions or comments? Seeing none, Vice Chair, as is.
Chair's recommendation is to pass SB 1270 as is, noting the previously excused members, any members voting with reservations, any members voting no. Chair, your recommendation is adopted.
Thank you very much. SB 1225, SD1, HD1 related to the University of Hawaii Board of Regents Independent Audit Committee. Chair's recommendations pass this out as is. Members, any questions or comments? Seeing none, Vice Chair, as is.
Chair's recommendation is to pass SB 1225, SD1, HD1 as is, noting the previously excused members, any members voting with reservations, any members voting no. Chair, your recommendation is adopted.
Thank you very much. SB 540, SD1, HD1 related to emergency rules. Chair's recommendation is that we adopt the amendments proposed by the Honolulu and Maui prosecutors and other technical amendments needed for clarity, consistency, and style. Members, any questions or comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass SB 540, SD1, HD1 with amendments noted to the previously excused members, any members voting with reservations, any members voting no. Chair, your recommendation is adopted.
Okay, thank you very much. So, members, we have a hearing on Thursday and possibly next Tuesday, but we'll let you know. You're adjourned.